Welcome to Sharpe Insights, conversations with your plan giving experts, a podcast for development professionals. Whether you're new to the field or looking to enhance your existing program, we will provide practical tips, expert advice, and real-world stories to deepen your understanding of plan giving. If you're committed to securing long-term support for your nonprofit, you've come to the right place.
Welcome to Sharpe Insights, conversations with your plan giving experts. I'm your host, Grant Miller. Today we're discussing a challenge many nonprofits don't anticipate until they face it firsthand: collecting funds from IRAs after a donor's passing. While naming a charity as an IRA beneficiary is simple for the donor, receiving those funds can be surprisingly difficult for the charity. Delays, confusing paperwork, and inconsistent procedures often pose unnecessary challenges. To address these issues, attorney and charitable planning expert Johnny Hayes conceived and launched the RIFT Project, which stands for Release IRA Funds Timely, a national initiative focused on honoring donor intent and improving the process for realizing charitable IRA gifts. A sought-after speaker and advocate, Johnny is widely recognized for her leadership in estate, charitable, and retirement planning. Today, Johnny joins us to discuss the RIFT Project's origins, progress, and what nonprofit professionals should know about receiving IRA gifts. Johnny, welcome to Sharpe Insights. We're so grateful to have you today.
Thank you, Grant. It's wonderful to be here and share some information with you about the RIFT Project.
Well, we're all looking forward to it. I guess we'll just start broadly. For listeners who may not be familiar, what is the RIFT Project, and what is the problem or the problems that it was created to solve?
Sure. RIFT, as you said, stands for Release IRA Funds Timely, and it's actually a double meaning because what we found is that there's actually a rift between the charitable organization receiving its rightful gift from a donor when he or she passes away and that financial institution that's holding that account and what it takes to be able to get that account paid. And so nonprofits have experienced an extreme amount of delay from many, but not all of these financial institutions when they are applying for one of these death benefits. And so their generous donors have passed away and maybe left, for example, an IRA to that charitable organization. And then when the charity works with the financial institution to receive that donor's gift, what they're experiencing is a tremendous amount of paperwork, delays, burdens, obstacles that are all brought about by the operational policies of these financial institutions. Now, some are pretty easy to work with, and others, what I call the asset conservation companies, what they do is they actually make the charity stop and become a full-fledged customer of that financial institution before they can ever receive the donor's gift. And Grant, what the problem is that making them become a full-fledged customer takes them into this regulatory environment that doesn't need to be there. By being forced to be a new customer, they are asking for personal and sensitive information from either a board member, all board members, an executive, maybe the CFO. But the personal and sensitive information that I'm talking about just to set up this new customer account are things like social security numbers, dates of birth, driver's license, passports, home addresses, the value of their personal assets. They're doing criminal background checks, credit checks, spouse's maiden name, names of your children, all this about an employee or all the board members. It doesn't really have anything to do with that charity to receive their death benefits. So some years ago, 10 or 12 years ago, I was on the board of the National Association of Charitable Gift Planners. And the board board had received a letter from a nonprofit saying that they were having trouble getting a death claim paid. And I, having worked for 3 financial firms prior to that time that offered IRAs, I knew that those should be paid out in 30 days. So it was of interest to me to figure out what's going wrong because I kind of knew that internal operating side of the financial firms. And so one thing led to another. I got more involved. And then I formed the RIF project, which is really a grassroots effort. It's all pro bono. It's all volunteer. And what we do is we try to help each other out in the charitable community and pass tips and advocacy and sample letters among the different charities for how they can get these gifts paid in a more straightforward, efficient, and quicker process.
So I'm just curious, what inspired you to take on this project and not maybe pass it on to someone else or...
Really, Grant, it goes back to looking at my past experience with IRAs and working with these custodians. I felt like the people in the room that I probably had the most experience in the internal operations of these financial firms, having worked for 3 that had offered IRAs and paid out IRAs. So I kind of knew how it worked. And I thought, if anybody's going to step up, this is the time for me to do it. And it's really a passion project. I mean, I have, a full-time job with Thompson and Associates that I love, but this is my volunteer kind of passion. And we've got to stick with it until we get progress made across the country that helps charities get their claims paid faster.
Well, on behalf of myself and all the rest of the folks in the industry, thank you so much for taking on this project. We really appreciate it. You mentioned the aspect of these financial institutions wanting charitable organizations to become a full-fledged customer. I guess this is a 2-part question. 1, why is that? And what's the workaround there?
Sure. Great question. So it's always follow the money. And in fact, yesterday I was just on a Zoom call with a lawyer from one of these banking lobbyist groups, and she admitted, which is the elephant in the room, why do they make you become a new customer? Because they certainly want to hang on to those assets longer. So instead of just paying a university out the death claim for $100,000 and paying that out in 30 days, some of these financial firms and broker dealers, by the time that they make you become a new customer, fill out 50 to 60 pages of forms. In fact, one broker dealer sent 800 pages. I know that sounds ridiculous. But so by the time it takes them to set up this new account, now they have all this information on somebody at the charitable organization. Then the charity has to go through a second process to liquidate that new account. And all this takes time. With the back and forth, so what they're finding out is that there is no uniformity among the financial firms on how claims should be paid. So this firm, might have this set of documents, a different financial firm has other sets of documents, and they'll say, oh, wait, we need one more form. Oh, well, we didn't like the way you signed this form, so here's another one. So a charity, typically it might take 8 submissions to get all the information to that financial firm to even set up the account. And now we have to go through the paperwork to close that account. And what the bottom line is for nonprofits is that it's taking years to get the money. So this donor has passed away, and it could be 1 year, it could be 2 years, it could be 6 or 8 years before they actually get the gift. And everybody, I think, in the charitable sector would agree that that's egregious. That's just way too long, and something needs to change.
So what are some of the steps that charitable organizations and the RIF project is taking to make some of these changes?
The RIF project created a database that is freely available. There's no charge. It is out there on the National Association of Charitable Gift Planners website. And you go out there and you click on the advocate banner across the top and scroll down to the RIF section. And what that is information by financial firm that each charity can look at to see how does that financial firm pay the claim? What forms do they need? Do they require an inherited IRA or a second account, those asset conservation companies? Or are they one of the companies that will just pay the claim quickly? And so, we've had good luck with Vanguard and Morgan Stanley on the IRAs. We've had wonderful working luck with Edward Jones, but then there are other ones that are very, very difficult. And so we have template letters where the charity can push back and say, we're not willing to open up this new account. Can we get an exception? Some custodians will offer an exception, but only if you know ahead of time to ask for that exception. So the database has all that information. It's also got some really great articles that explain the RIF project and what the issues are. So you can educate your board, or you can educate your CFO, or educate others that you need about that. Grant, another thing that we're just putting out there now on that RIF database is we've had wonderful success with several states enacting laws that prevent some of this draconian paperwork. And so Iowa started 2 years ago, and they were the first state in the nation that passed a law that said that the custodians cannot ask for more than certain information from a charity. So none of the personal information can be asked for, and the basic information you would think you would need to pay a claim. Just the straightforward information. The Iowa law says that they have 30 days to pay the charity, and wonderful, wonderful resolutions that if the financial firm doesn't do that, the charity can file a court action and receive attorney's fees and damages and all that kind of good stuff. And then Indiana did a law the next year, although not really that favorable for the charities. But then just this spring, Grant, Colorado, Nebraska, Tennessee have all passed laws in their own states. Illinois is waiting for the governor to sign their law this summer, and California is still in that legislative process. So what we found, Grant, is that these financial institutions won't do anything to really make it easier for the charities until we get some laws passed. And so next year, we have about 20 states that want to do that in their own state to protect the charities so that they only have to provide the basic information that a financial firm needs to pay the claims. And so really, as a nationwide community, we're really working together to protect the charities so that they can receive those donors' gifts on a timely basis.
That's great. So we're moving through legislation, sounds pretty quickly through the states. That's amazing progress, because I know sometimes legislation and that sort of thing can be pretty slow. So I'm glad to see that we're making some pretty quick process there. So outside of these institutions asking organizations to become a full-fledged customer, or I just kept thinking like, oh, it sounds like a stalling tactic in a way. Is this just like the single issue affecting organizations when they're trying to receive these IRA gifts? Are there other obstacles that are in the way there?
It's mostly the being forced to become a new customer, because that triggers then all these federal government regulations when financial firms open accounts. So there's like bank secrecy and know your customer rules and all that kind of stuff triggers when they're asked to be that new customer. And so the financial firms can pay the claim without making you be a new customer. They just don't want to, right? So they might have to do a software patch or something like that, right? That all the other companies have to do when things change. And it's all about that money, right? It's who's holding the money longer, just as that lawyer said yesterday, because the longer they hold the money, the more fees that they earn and the more profits. And we understand that, even though we're, a nonprofit community, we understand their need to make money. But when the rules that they set up on a company by company basis, these specific operational procedures they have are so ridiculous and so out of line for what's happening. That's when we've said we've had to push back. And it's also the time. Some of the laws that I've mentioned, one of the things that we're adding, Grant, is that the financial firms now in these states have a duty to notify a charity when they're the beneficiary. And you might think, well, they don't do that. And the answer is no. In fact, Charles Schwab says right on its forms that has no duty to ever notify a beneficiary that somebody has died and they're the named beneficiary. And so we had one broker dealer that was actually the 401k administrator for a university. And they knew that the employee died and the employee had left their entire 401k to the university. Again, the broker dealer's client, but they never told the university that they were the beneficiary. And 16 years went by, and that money stayed at the broker dealer, making them lots of money every year. And the poor university that was actually paying them to administer the plan, broker dealer, wouldn't even tell them they were the beneficiary. So it's those sorts of practices and things that are hurtful to the charitable sector that we are trying to prevent from happening. And so that's just one example. Some other things that are taking time, some of these financial firms want the CFO of the charity to be on the phone and actually liquidate the accounts. And we had one national charity that CFO was on the phone, and yet that large broker dealer had the CFO on hold for over 8 hours. Now, you all know that CFOs don't, first of all, they don't have time to be on the phone to liquidate accounts when they can give ability to do that to one of their staff people. So what I'm saying is the obstacles that they are setting up are making it nearly impossible for the charities to receive their dollars. And that's when things are just plain wrong. And we need to be able to push back. And that's what the RIF project is there to do.
Great. So this question, I'm trying to figure out it might be a three-parter. So we'll try to break it down. But one is, in this industry, it's really all about the donors and the donors' intentions. And I know oftentimes donors, as we're talking about, won't really notify an organization if they have made them a beneficiary of an IRA. So, with donor intention in mind, what can organizations do ahead of time to maybe get out in front of this issue a little bit?
Sure. Grant, I think that to the extent that nonprofits and their development staff can have conversations with their donors, encouraging donors to disclose ahead of time that they're making a gift. Now, I know that donors are reluctant to do that because they don't want to feel bad if they have to end up using that IRA for their own care during their lifetime. And they don't want to tell the university or the hospital or the women's shelter that they're going to leave a gift, and then at the end of their lifetime, they had to use all that money and there wasn't a gift there. And they should be told that and informed that the universities and the nonprofits are okay with that. They know it's the donors' monies first. But please allow us to at least know about the account. And if there is money there, it will allow us to receive their generous gift sooner and be able to put that money into the mission or the particular program that donor so loved. Because that is how we are able to know and to be able to apply for that death claim and get that money faster if we're aware of it. On the RIF database, there are some articles that nonprofits can put in their newsletters or sample wording to talk about that conversation with their donors. But that one-on-one conversation is generally the best way to do that. But we do offer some website and newsletter articles complimentary through that RIF database because we're talking about the impact, right? What is the impact? And just one nonprofit client shared with me that at the time that it took to get just one death claim paid, just one, that they could have given out with the lost amount of income, they could have given out 3 full ride scholarships to deserving students. in the time that it took. And that's the impact that this is having on charities. So there's a real life impact on our mission when these delays and tactics that we're having on the business side from some of these financial firms, it is hurting everyday charities.
Yeah, exactly. And I'm glad to hear that you offer resources about some language around this and some framing in ways that organizations can talk to donors during their lifetime about just how to approach this long term. Even, that's a really good point about people being concerned about saying, I'm going to leave you this, but then end up not really being able to. So are there any, you've talked a lot about this, but I guess can you just let us know, like, what are all of the resources that the RIF Project offers organizations? I know you have a lot of just information out there, but is there anything advocacy-wise or consulting-wise or anything like that you all do?
The Rift project on the database, what it does is, first of all, it has articles about the issue. And those are really important for people to read to understand what the issue is. And so those resources are really important and available. For example, yesterday, working with an attorney, the attorney said that the IRS requires the financial firms to open up an inherited IRA. And I said, no, that's not true. The IRS does not do that. And so the articles can help educate everyone so that when we're getting bad information, whether intentionally or unintentionally, from the financial firms, that we can gently push back and say, no, that's not really true. That's not how it works. We also had, in terms of advocacy, Grant, we have the various state laws out there. We have the sample model law for the other states to use. And then what we're going to be adding are the sample letters for each state to use, because what we're finding out with the state laws is that these financial firms are just pretending like they don't know that law is out there. And they're sending the 60 pages or the 800 pages of forms to the charities in those states, thinking that they'll just go ahead and fill out all that information and open up that new account. And so we've got the pushback letters, we've got the affidavits, and those other advocacy things too. I work with, as part of RIFT, I work with all the different states to help get them started. I keep a list of who's working on this legislation in each state so I can connect one another. There might be 10 people in Texas, but Texas is a big state. So how do we connect them? And then I supply them with all the information they need to get up and get started on that state law. So we have that information out there. We have the articles that I was telling you about encouraging donors to disclose. And there's probably, maybe 10 different segments out there on that RIF database. We like to keep everything freely available. You do not need to be a member of the National Association of Charitable Gift Planners to access it. And we know that the brokerage firms out there, they know all about it. In fact, we've had several of them try to reach out to us to ask us to take their names off of things or not to send letters to their general counsel. So we know that we are being heard as an industry, and so we know it's being effective.
Excellent. Well, thank you so much. We appreciate it. So if a nonprofit learns tomorrow that they have been named the beneficiary of an IRA, what advice would you give them for next steps and just kind of how to approach that from now until they actually receive that IRA gift?
Grant, the first thing that I would have them do is go to the RIF database and look up that financial firm. Is it Fidelity? Is it Ameriprise? Is it LPL? And find out how they pay the claim. If it's the type of company that doesn't require the inherited IRA or the brokerage account to be opened, right? The ones that don't require you to become a new customer, you're going to have a nice, smooth, easy job. Keep records of everything, keep photocopies of everything that you send. If it is one of the financial firms that requires that inherited IRA, then follow the procedures on the RIF database, push back to the extent you can, and sometimes we'll tell you on the RIF database, This financial firm has never made an exception. But some of our letters encourage you to also carbon copy your state attorney general, carbon copy some of the Senate Finance Committee folks that we're trying to share with them what this problem is. And so have those letters come from your general counsel to the general counsel at that financial firm. What we've learned, Grant, is that if you're just talking to the clerk at that financial institution, the person that's just sent you the forms perhaps, they don't have the authority to make an exception. And so we always want charities to be prepared to escalate, to ask to push back against their requirements, and to escalate their exception request to either the head of compliance, the head of their anti-money laundering, or their general counsel, because those are the levels of the people at those financial firms that will be able to grant an exception for us. So oftentimes at that entry level that we're working with, those are not the people that we can get that exception from.
Well, it sounds like the RIF project has a lot of work to do, and it sounds like you've been making a lot of really positive progress. Are there any other, I guess, bigger issues or challenges that the RIF project is facing moving forward? And if so, is there anything that the rest of us in the nonprofit world can do to help move that progress forward?
The National Association of Charitable Gift Planners 2 years ago hired a lobbying firm in Washington, D.C., and their task is to try to get some federal legislation going. And so the RIF project is working really on the state level because progress in terms of a federal law has not actually been made yet. And that might be the ultimate solution, is one federal law that prohibits what's going on with these financial firms. But in the meantime, our states are taking care of the issue, and we're making progress at the state level where we can't at the federal level. But the other thing that is really helpful for each nonprofit is if your people that, your staff that are doing the death claims want to join a group that RIF forms. So RIFT is the overall movement, but we have a segment of that called RIFT Advocates. The RIFT Advocates are employees, people from all the different charities that pay the death claims, supervise the people that pay the death claims, or, estate lawyers that are just helping us. They meet once a month by Zoom. So it's no cost to join. Again, RIFT is all pro bono. But what they do is they get together every month and they share tips. And somebody will say, I'm having trouble with Raymond James this month. Does anybody have a good contact at Raymond James that we can get this claim paid through? And they share information, they help each other out, and we meet every month. And it's just a great way for us to be together as a nationwide community and help each other out where we need to. So again, joining RIFT Advocates, you can do that through the website. Again, on the national website, under the advocate button, under the RIFT then section, you can join. And again, you don't need to be a member of NCPG, but it's a great way to participate and help your own organization with your claims issues.
Excellent. That's very resourceful. So I've been writing about IRAs and communicating with donors about IRAs for a long time. I'm pretty unfamiliar with this end of things. Like, this is actually the first I've been hearing about all of this. So just based on my own inexperience, a lot of times I don't know what I don't know. And so I don't always know what to ask. But in this case, is there anything that I haven't brought up that you want to mention or you think that we should talk about?
I think we have covered a great deal of information about this issue. Why are IRAs? Why is this an issue? And the issue because IRAs are the best number one asset for a donor to use to make a charitable gift at death. There's no better asset. Years ago, I did a presentation about the IRA wins the Oscar for the best tax performance in a charitable gift, right? And so professional advisors all over the country and charity plan giving staff were always telling donors about how IRAs are such an extremely fantastic tool to use in estate gifts. And so more and more gifts are coming down the pike because it's such a good way to do it. But what happens is on the back end, there's this dark side created by these financial firms with their greed and their profit motive that they're really trying to suck the life out of us in terms of hanging on to our donors' gifts and taking years to pay. And so that ugly dark side is what we're trying to prevent with the RIFT project. But Grant, I think we've done a great job today talking about the issues and the support that's available in those articles to read and distribute to your board, to your organizations. I guess I want to end with one more story of what this impact is. And so there was a national organization that everybody knows, and on the board of that organization sits on the board all the living first ladies of the United States of America. And one of these financial firms demanded that in order to pay the death claim, that they get the social security number and the driver's license of everybody on their board of directors. Well, A, there's no legal reason for that. And B, can you imagine? So what happens is these organizations, these charities have to end up never getting the money because the obstacles are too tough, too hard. You can't overcome them because nobody's going to ask the first ladies for their driver's license and their social security numbers just to receive a payment. So these are good charities that aren't doing terrorist activities. They're not funneling money. Terrorists are not working and leaving their death benefits and their IRAs to terrorist organizations when they die. So the rules that they're using when they're trying to not funnel money through terrorism just don't apply to us. But the people in the federal government won't open their eyes to say, you know what, these rules don't make sense. These new customer rules don't make sense. So instead of trying to fight the government on that, we are going with our laws that say you can't even make us become a new customer. And therefore, we don't go down that deep, dark alley. And we just get paid, hopefully within 30 days, without having to open a new account. And that is the crux and the sole purpose for the RIFT project, Grant.
Well, that's awesome, Johnny. Thank you so much for the important work that you're doing out there for the nonprofit community. And thanks for joining us today here on Sharpe Insights. It was really good to have you.
Thank you so much.
For more information on the RIFT project, you can visit charitablegiftplanner.org. And if you enjoyed today's episode, please subscribe, share it with a colleague, and join us next time for another conversation on the ideas, people, and strategies shaping the future of charitable gift planning. To all of our listeners, thank you for being a part of this conversation. Until next time, I'm Grant Miller. Thanks for listening. We hope today's discussion gave you practical takeaways to grow your plan giving program. To submit questions and topics for future episodes, go to sharpegroup.org or listen to us on your favorite podcast app. If you found this podcast insightful, be sure to like, review, and subscribe. Until then, stay sharp.